Hello, folks. Todd Halleck here, talking to you a little bit today about asset protection and the benefits of using a limited liability company. The story involves a couple, David and Kate Bartenwerfer, who owned a home together in San Francisco. They weren't married at the time, subsequently did get married, but they jointly owned this home. And David was going to do all the work and sign all the contracts. And Kate, she was basically just a passive investor, just provided some money, and that was really her only involvement. Eventually, David sells the home to a person by the name of Kieran Buckley. When Buckley got the home, Buckley realized that there was a lot of problems with the home that were undisclosed, and ultimately sued the Bartenwerfers in California court and won a judgment against them for $200,000. Apparently, this wasn't the only debt that the Bartenwerfers had, so they, married at this time, determined to file bankruptcy. In the bankruptcy court, it was ultimately determined that the debt was non-dischargeable, meaning that they couldn't get out from under the debt. They still had to pay the debt because the debt was paid by or was obtained by fraud. Kate challenged this decision and initially prevailed that she was not engaged in any of this, and so therefore did not commit fraud of any kind herself. This went back and forth through the court system, with both parties appealing the case, and ultimately landed in front of the United States Supreme Court. And the court issued its decision this past February, finding against Kate and determining that general partnership existed between her and David, and as a result, she was jointly and severally liable for the debts that he incurred. And if the debt was non-dischargeable for him, it was also non-dischargeable for her, meaning that even though she filed bankruptcy, she couldn't get out of this debt, and they would still have to pay Buckley. So this case mostly deals with some nuances of bankruptcy law, and that can be a really difficult place to find yourself. But for purposes of this video today, what I wanted to talk about was an off-the-cuff statement in the opinion where the justices referenced the fact that Kate, if she was concerned about this, could have, instead of being in a general partnership, had been involved in some form of limited liability entity, such as a corporation or a limited liability company. The benefit of being involved in that type of an entity is that if there is a debt or liability of the company, you as an investor, you as a stakeholder in the company, are generally only liable to the extent of your investment in the company. And so if she put in, say, $50,000 into the original investment in an LLC, that's all that she had at risk. But because they did things as a general partner, she was unlimitedly liable for the debts and liabilities of the company, and then stood to be equally responsible for David's misdoings in his situation. And so the moral of the story, other than obviously don't commit fraud, is don't do business with someone who is going to commit fraud. And if you do, be careful and do it in the form of a limited liability company. Again, don't commit fraud, don't do business with someone who will, but you don't always know that. And so better off being in a limited liability company. This is even the case for husbands and wives, as we have here, right? Just because they were married, they weren't going to be jointly and severally liable for that debt. And it didn't appear to be the community property issues in California that caused Kate the problem. It was the partnership rules in the state of California. So just a word to the wise: if you're going to do business, there's really no excuse not to have some form of limited liability entity. You'd want to work with your accountant, your attorney, to determine which is going to be right for your situation. It's not a one-size-fits-all, but I would definitely encourage anything of this nature to be done in a limited liability company. Minimize your future exposure. So no reason, with a little planning, Kate couldn't have had a lot less troubles. And I hope her hard lesson will be a good lesson for all of us.